The clerk will open the court.
Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas in this honorable court.
Thank you. Good morning. We have 3 cases on our submission schedule this morning, and we're ready to hear argument in the first, which is 19-282, Waste Management of Texas versus Stevenson from Harris County and the 14th Court of Appeals District.
May it please the court, Mr. Smith and Mr. Gunn will present argument for petitioners. Petitioners have reserved 5 minutes for rebuttal. Mr. Smith will open and Mr. Gunn will present the rebuttal.
Good morning, Your Honors, and may it please the court. Petitioner Waste Management of Texas employs upwards of 200 temporary workers from Taylor Smith Consulting. They're all employed on materially identical facts. For injuries big or small, we provide workers' compensation. We take responsibility. If uncertainty exists as to the employment status of Mr. Stevenson, then uncertainty exists as to all. That contradicts the certainty that's to be provided by the workers' compensation bargain. As this court held in Wingfoot, temporary employees should not have to guess who their employer is for workers' compensation purposes throughout the course of the day. The Court of Appeals gave 2 reasons for holding that uncertainty exists. The first was that the injury took place off of Waste Management of Texas premises. And the second is the role of this contract with a separate and distinct waste management entity. I'll address both points in turn. The first point, premises, should not take long and may not even be controversial, but it is of immense importance to employers such as Waste Management of Texas that regularly send their employees off-site in order to perform their jobs. As we detailed on page 15 of our brief, there's considerable uncertainty in the lower courts among the role of premises in determining whether or not an employee is actually an employee. We asked this court to hold that the statute means what it says, that section 401.011, definition number 12, means what it says when it states that the course and scope of employment includes injuries that happen on the employer's premises as well as at other locations. To hold that an employee ceases to be an employee merely because they are injured while carrying out their employer's instructions off-site would inject considerable uncertainty into the law. As Justice Devine's Orozco opinion explained earlier in March, the deputy sheriff who was tragically injured or killed on I-10 was acting in the course and scope of his employment, even though the injury happened on I-10, not on the premises of his employer.
Mr. Smith, I think the deputy in that case had his, if I recall, the dispatch on, and if he'd seen an accident, he'd be required to pull over. I think the general orders in the department required that and that sort of thing. Do any of those nuances make a difference here? What if this accident had happened while they had stopped, I don't know, at a different location to pick up lunch, still on the job, but picking up lunch? Does premises matter at all?
There could be cases at the border where maybe the coming and going doctrine comes into play. But in cases like this, where the very nature of the work itself takes the employee off of the premises and they're performing work, their employer's work, off of the premises, then premises should not make a difference with respect to whether or not they are an employee. Maybe it could come into play with respect to course and scope, Your Honor. It should not come into play with respect to whether or not an employee is an employee for workers' compensation purposes.
And you agree that the master agreement is unambiguous about the status of Mr. Stevenson as an independent contractor?
Right? As to the parties to the contract, Your Honor, yeah, that's correct. With respect to the contract, first I'd like to make a background point, and that is this court's holding in City of Bel Air versus Johnson. We submit that controls. In that case, there was an injured temporary garbage truck helper, and this court held that he was indeed an employee of the garbage truck collection entity for purposes of workers' compensation. This case is indistinguishable, and the only conceivable distinction would be this contract. But 3 points about the contract, Your Honors. First, we've provided the relevant parts of the contract at tab 1 of our bench exhibits. And first, Waste Management of Texas, the defendant in this lawsuit, is not a party to the contract. Waste Management is defined in the contract to mean Waste Management National. The second point is that the parties to the contract knew how to refer to affiliates when they wanted to. At the second paragraph from the top, the court will see that they define the word company to include both Waste Management National and Waste Management National's affiliates. So if they wanted to refer to affiliates, they could have used the word company. Then at the bottom of page 1, in paragraph 2, the court will see that Waste Management National entered into this contract not to secure services for itself, but to secure services for related entities and affiliates. Again, the parties knew how to refer to affiliates when they intended to.
To that end, is your client an intended third-party beneficiary of the contract?
Yes, Your Honor, and we aren't quibbling with the terms of the contract. The contract on the next page in paragraph 3 says that Mr. Stevenson is an independent contractor as to Waste Management National. We agree with that statement. Waste Management National entered into the contract to provide temporary labor for its affiliates throughout the country.
Mr. Smith, if I understand you correctly, are you saying that if the contract was between the party and your client, the affiliate, then it would be clear that this was an independent contractor? Is that what you're saying?
Close, Your Honor. Then it would be clear that they were an independent contractor, at least for some purposes. And I'll get to the distinction between the meaning of independent contractor and employee in different contexts in just a moment. But the most important point is that we're dealing with a contract that describes Mr. Stevenson's relationship with respect to Waste Management National. And that makes perfect sense because Waste Management National was not entering into this agreement to procure services for itself, as paragraph 2 of the contract explains. So of course, these temporary workers who weren't intended to provide services for Waste Management National in the first place are independent contractors as to Waste Management National. That does not make them independent contractors as to Waste Management Texas.
What does it make them to Waste Management Texas? An employee, even though they're an independent contractor of the parent company?
Your Honor, that means that the contract is silent as to Mr. Stevenson's relationship with Waste Management Texas, and therefore the contract itself cannot create a fact issue.
If we disagree with you about that, Mr. Smith, and think that the contract is relevant, then maybe you can address another case, our decision in Energy Transfer versus Enterprise, where we held that freedom of contract trumps the multi-factor common law analysis of partnership. The other position in that case was that the contract was one factor to be considered, but I don't think anybody in that case argued that the contract was simply irrelevant. So I can understand why there's confusion in the courts on this point about, when does the contract control, when is it relevant but not dispositive, and when is it completely irrelevant? Can you help take us through that? Why is the contract irrelevant when it was dispositive in Waste Management? In Energy Transfer.
Your Honor, there's 2 responses to that. First is our point that the contract does not address Waste Management Texas. The second, even if it did, the words independent contractor and employee mean different things in different circumstances. And here in this case, in paragraph 3, the parties are using independent contractor and employee, employer to refer to administrative tasks such as payroll or the provision of benefits or who must perform services such as immigration checks. Those are substantively different from the right of control inquiry that is at the heart of employment status for workers' compensation purposes. The mere fact that Mr. Stevenson received pay from his temporary employment agency is not inconsistent in the least with Waste Management Texas having the right to control the details of the work. The contract
is it right to control or is it actual control? I thought our cases, several of our cases look at actual control rather than just right of control in this context.
Actual control, Your Honor, is probative of the right to control. The City of Bel Air versus Johnson emphasized the right to control. Garza and Wingfoot emphasized that actual control is a traditional indicia of employment. In other words, it points to whether or not there is the right to control in an employment relationship. And so the undisputed facts on the ground are that Waste Management of Texas had the ability to control Mr. Stevenson's actions in his work, and indeed did control it down from the details of prohibiting him from crossing from one side of the street to the other, requiring him to go on the particular route that he went on this day, even though he didn't want to. They controlled every aspect of the details of his work and are therefore, as a matter of law, on the undisputed historical facts, Waste Management of Texas is his employer for workers' compensation purposes.
Mr. Smith, what contract governed the relationship between Waste Management Texas and this employee in terms of salary, pay, benefits, any other terms that would typically apply in an either employment or independent contractor relationship? Was there any kind of contract that applied here at all?
There was an implied contract of hire between Waste Management of Texas and Mr. Stevenson. And that's the very definition of employer and employee in Chapter 401 of the Labor Code and the Workers' Compensation Act. Talks about an implied contract of hire. And while it may be difficult at times to determine what the precise terms of an implied contract might be on facts like this, the existence of the employment contract of the right to control is just as clear in this case as it was in Garza, where even though there was one master, the temporary employment agency that provided payroll, that provided insurance, that handled training, and so on and so forth, that did not prohibit the client from simultaneously being an employer as a matter of law for workers' compensation purposes. Your Honors, if there is uncertainty on these undisputed historical facts, then that means that Mr. Stevenson may or may not be an employee or an independent contractor, and his co-workers from Taylor Smith, provided on materially identical facts, may or may not be an independent contractor or an employee. And it's impossible for anyone to know until years down the road when different juries tell us who is who, all looking at the same undisputed historical facts.
If Waste Management had, sorry.
How is that any different than having to apply this control test that we've developed through the years? In each individual case, you've got to wait until a jury decides whether the amount and details of the control are sufficient to constitute the level of control that would create the employment relationship. How's it any different? I mean, it seems to me the easy answer is what Justice Busby said, which is if you do have a contract that governs, then that governs regardless of whatever level of control there is. I mean, I know you don't think this contract applies, but if it did apply, then wouldn't the argument that you're making now favor applying the Energy Transfer Partners rule and say, look, if the parties agreed that you're an independent contractor, then that's what you are regardless of the amount of control?
Both in the workers' compensation context, Justice Boyd, and under the common law. It's been the rule for centuries that parties can implicitly modify contracts. And that's why the courts have consistently looked to evidence on the ground of exertion of actual control in addition to the terms of the contract. But in this case, we submit that although contracts are intended to provide certainty as to the contracting parties, it should not be the sole piece of evidence that creates uncertainty as to the rest of the world.
But you're suggesting that it shouldn't even be a piece of evidence.
Yes, Your Honor, it does not address Mr. Stevenson's relationship with Waste Management of Texas, nor does it address the crucial issue in this case, the right to control the details of the work while Mr. Stevenson was performing his work on that day.
Isn't that an element of the independent contractor test?
The right to control is the core issue that this court emphasized in the City of Bel Air case, the Exxon case, and decades beforehand.
So how can you say by saying independent contractor, it doesn't address the issue of right of control?
In this context, in the issue in paragraph 3, the parties are discussing payroll, benefits, other things traditionally associated with who is an employer for administrative purposes. But that does not mean that the contract addresses the right of control. And I'd point this court to the first court's decision in the Flores v. North American Technologies Group case, where the first court examined contract language saying that a temporary employee would be solely the employee of the temporary agency. And the first court nonetheless held as a matter of law that he was also an employee of the client. We ask this court to reinstate Judge Landrum's summary judgment.
Any other questions? Thank you, Mr. Smith. We'll hear from the respondent.
May it please the court, Mr. Hogan will present argument for the respondent.
Mr. Chief Justice, and may it please the court, allow me to begin with this contract argument that somehow the contract doesn't cover the party in this case.
Do you want to turn your video on, Mr. Hogan, or not? It's up to you. There you are.
Sorry, Your Honor. Thank you.
All right.
Mr. Chief Justice, and may it please the court. Waste Management and all of its subsidiaries are expressly stated to be third-party intended beneficiaries of this contract. And the designated corporate representative for Waste Management swore that the master agreement was in place and covered Robert Stevenson at the time of his injury. That's in the clerk's record at page 892 in the first volume. The petitioner has demanded and obtained indemnity under that contract for the claim that's being made by Mr. Stevenson. Now, this contract's language was meant to have something of an evidentiary import to show that Waste Management had no obligations to Stevenson as an employee and no respondeat superior liability for third persons. But those words in the contract that relate to employment status still count outside the employee benefits and vicarious liability contexts. They should be a factor to be considered, although not controlling, in whether Stevenson, who was an employee of Taylor Smith, became an employee of Waste Management. And of course, Waste Management argued that very point in citing this court's opinion in Exxon versus Perez in their response to the motion for summary judgment at page 909 of the clerk's record. On that summary judgment record, employer status is not conclusively established, and therefore the Court of Appeals judgment should be affirmed.
If the contract is a factor, how could it not be controlling?
Well, Your Honor, it would have great import. It could be controlling in terms of what it says about employment status. It does not, however, this court has said in Exxon versus Perez, always conclusively establish that fact. Now, I don't want to interpret what the court means by that, but I will say that this court has often said that contracts, when the parties have agreed to them, and these are well-situated, highly sophisticated bargaining parties that reached this agreement. And as between themselves, they decided that Mr. Stevenson would not be an employee. But how is an employer-employee relationship established? That's the key question before the court. And the court has answered that it's not done by the statutory definition alone for either employer or employee. The statutory definition in the workers' comp statute, the court has said, is one piece to the puzzle, but it does not in and of itself tell us whether, as the court said in Garza versus Excel, whether Garza was Excel's employee. To fully answer the question of who is an employer and who is that employer's employee, the court must look elsewhere. Also, the definition of employee in the statute is not entirely helpful. There is no indication from the legislative history of the definition of employee in the workers' comp statute that the legislature intended to dispense with traditional notions of employment relationship status, such as the right of control test. Words and phrases, the court said in the Garza case, that have acquired a technical or particular meaning, whether by legislative definition or otherwise, shall be construed accordingly. So the court's inquiry into employment status in this, as in every case, is governed by traditional indicia. The court uses that term, traditional indicia, such as right of control. In determining if a general employee of a temporary employment agency is also an employee of the client company, the court considers those traditional indicia, such as the exercise of actual control over the details of the work that gave rise to the injury, and that's the injury. That's this court's opinion in the Garza case at page 477. The court considers, I'll say again, traditional indicia, such as the exercise of actual control over the details of the work that gave rise to the injury. So as this court has said, oftentimes, the right of control test, perhaps one of the most important, if not the governing factor in an employment relationship, standing alone would defeat this summary judgment because of the testimony. But this court has...
If we look at right of control or actual control, the cases seem to use both.
Yes, Your Honor. And the question of actual control, I would agree with Mr. Smith, obviously is indicative of a right of control. But the court should look at the exercise of that control, because if you don't exercise the control as the employer, you're removing one of the policy considerations for why a master-servant relationship creates liability and why sometimes it would govern the ability of an employer to work with that employee. So actual control is a key part of the right of control test. It may not be an either or, Justice Busby, but it very well could be something that the court ought to look at.
It's like something we'll have to look at on these facts, because as I understand your summary of the evidence, there is evidence that there was not an exercise of actual control at the time of the injury, but there's also evidence of right of control at this, of the work that was going on. So how specific or general do we get on that?
Your Honor, of course, the court is considering in this instance a summary judgment. And so if there's evidence on both sides of that summary judgment ledger, then we win. In other words, if there's some evidence, and we should credit to some extent Waste Management's evidence about their ability to control, but that does not conclude the summary judgment. It is not conclusive evidence. The evidence, as Your Honor noted, is in this case that in fact there was no actual exercise of control. There couldn't have been any exercise of control because of where Mr. Stevenson was positioned in relation to the driver, who was the supervisor, and that driver could not communicate well in English. So it's a question in this case of whether there's some evidence, more than a scintilla of evidence, to indicate that Mr. Stevenson was not subject to the control of Waste Management, certainly not at the time of the injury, and we would argue that not at other times also. Now, the right of...
Mr. Hogan, how is that how you're distinguishing this from City of Johnson versus Bel Air, where we looked at the work schedule, the assignments, the supervision of the work? Wasn't there a supervisor on that truck at all times? And if somebody, wasn't doing the work exactly right, that person would have the right to control those details, wouldn't they?
Your Honor, as the court said in City of Bel Air, and Your Honor is referring to page 923 of that opinion, the question in that case that the court posed was whether a worker is an employee rather an independent contractor. And the court said the test is whether the employer has the right to control the progress, details, and methods or operations of the work. And the court noted that the distinguishing factor and the important factor in the City of Bel Air case was that the city had set Johnson's work schedule, gave him his assignments, and supervised his work. And they said that the temporary employment agency, in that case, Mangum, had no role in overseeing Johnson's work. Of course, in this case, we have such an important piece of evidence, which is an admonishment from Taylor Smith, the temporary employer in this case. And this is at page 838 of the clerk's record, I believe. They had to counsel Mr. Stevenson for not following the proper chain of command through Taylor Smith, and in being admonished to not go to Waste Management for his complaints about his services with Taylor Smith. So they asserted that they had the supervisory right of control, which distinguishes this case in part from the City of Bel Air case. But let's look just at the non-contract evidence, because it's easy to sort of focus on right of control. And perhaps I can give an analogy to the court that might prove helpful. Let's suppose a group of lawyers got together and they had an agreement among themselves that one of them would be an associate and the other 3 or 4 would be partners. The court wouldn't say that's no evidence of whether a partnership relationship existed. In fact, if the court says that partnership is governed by things like an agreement to share expenses and income, the court wouldn't say, well, the contract has no relevance to partnership status just because the real test is sharing income and expenses. In this case, every document in the record indicates that Taylor Smith is the employer, not Waste Management. That's outside the contract. Waste Management's corporate representative wasn't aware of any documentation supporting the idea that Mr. Stevenson was an employee. There was no direction or control by the Waste Management driver, who wasn't paying attention to Mr. Stevenson, who was on the other side of the truck, who couldn't speak Mr. Stevenson's language well, and needed an interpreter even to interpret his address in the deposition he gave. And the corporate representative of Waste Management agreed that if the driver was not in control at the time of the accident, then Stevenson would not be a Waste Management employee. He testified to that fact. But that's outside the contract. That's evidence on our side of the summary judgment ledger. And that's why Chief Justice Frost, in her opinion for the 14th Court of Appeals, said that this summary judgment was erroneously granted. But let's look at the contract itself, because apart from my analogy about partnership status, although the contract is not dispositive, it counts in the summary judgment ledger. Waste Management is not the employer. Taylor Smith is responsible for performing traditional indicia of employer duties. Those include hourly payments, benefits, hiring and firing, discipline, training, providing of PPE equipment, and drug screening. It also includes supervision, as I mentioned a moment ago, as in violations, they said, of the employee handbook, which prohibits addressing issues with the client, they said in that employee handbook, instead of going through the proper channels within Taylor Smith. And that's why Mr. Stevenson, because he went through Waste Management instead of his employer, got his final warning. And this is at clerk's record, pages 833 to 34. So all of those traditional indicia of employment status count: the contract, the testimony, the documents. All of those count and are the reason why this summary judgment was erroneously granted. So let me argue to the court specifically in response to some of the arguments that my friend so capably gave to the court. The court can't rely on grounds and arguments that weren't raised below. There's this argument about the splitting of the workforce in the port terminal rail case that this court considered some time ago. And if anything about splitting the workforce is a problem, that's a problem of Waste Management's own making from the way that they wrote this contract. as the employer in this, there is no splitting of the workforce problem because Waste Management, of course, is allowed to have independent contractors. Most of the refineries and chemical plants along the Houston Ship Channel regularly have independent contractors, but they all have comp. And getting comp is the reason why the splitting workforce problem has ever been a problem at all. As this court has said in both the Wingfoot and City of Bel Air cases, there are exceptions to the rule against splitting a workforce. One of them is if the employer leases employees under the Staff Leasing Services Act. And so the splitting workforce argument is not a problem. If employment status is unclear, a fact issue has been raised in this case precisely because Waste Management chose not to follow the statutory scheme that the legislature gave to parties like Waste Management. They argue in their briefing that somehow this person, Mr. Stevenson, is a temporary worker and that temporary workers aren't covered by this statutory scheme for professional employment organizations and staff leasing services. But the term temporary has both colloquial and legal meanings. Let's look at the ordinary colloquial use of the term temporary. The temporary worker label is not used by some of the witnesses in the legal sense that is commensurate with Texas's staff leasing laws. Waste Management's lawyer questioned him and questioned the driver and questioned why Mr. Stevenson, who was an experienced worker, meaning he had been there for a long time, would have done what he did. The corporate representative said that workers from Taylor Smith are not temporary because, quote, some of them have been with Waste Management for quite some time, a number of years, close quote. So the colloquial sense of temporary may mean one thing, but even in that colloquial sense, Mr. Stevenson was not temporary under some of the evidence. It's not conclusive that he was temporary. Second, the defined legal meaning of temporary under the Staff Leasing Services Act and under the current statute is defined. Temporary help means an arrangement by which an organization hires its own employees and assigns them to a company to support or supplement the company's workforce in a special work situation. And this is in the Labor Code, Section 91.001, and the same sort of distinction existed under the Staff Leasing Services Act. Now, the Professional Employer Organizations Act discusses an ongoing relationship to create co-employment status, which is what Waste Management really wants here. They want to say that not only is Taylor Smith the employer, but so are we, Waste Management, the employer of this worker that we hired through the agency. An ongoing relationship, which is what the facts show in this case, because of course, Mr. Stevenson had been working for Taylor Smith at Waste Management for over 2 years. They could have created a more ironclad, clear, and determinative relationship if they had followed the legislature's careful statutory scheme, but Waste Management chose not to do that. And rather than write a ticket for this train and day only, the court ought to simply affirm the summary judgment, decide that there are fact issues to be determined, as Justice Boyd suggested in his questioning, as to whether the control that was exercised in this case was sufficient to create an employment relationship. It was not under the contract, under the testimony, and under the documentation. And we ask that this court affirm the Court of Appeals.
Mr. Hogan, how can we provide some clarity here and guidance for the courts of appeals? I think Chief Justice Alley's concurrence in the El Paso Tool case points to some difficulty in the courts of appeals in applying our jurisprudence in this area. So what would you say about what additional guidance we should be giving as to what the rule ought to be, not just for this case, but for other cases, so that courts know when it's proper to grant a summary judgment and when it's not?
The courts often said that, Your Honor, and you're agreeing with the predecessor courts like in McKay and in other situations where the court has said that's a difficult question. And I think anytime the court confronts cases with different facts, different contract language, and that sort of thing, it's a difficult question. I think the court ought to encourage parties who want to engage in this ongoing co-employment relationship to follow the carefully set out statutory scheme. The court could suggest that that might be a better way to go about this, and then you're not dealing with changing facts and changing contract language. The contract should have preeminent importance. It has importance under the Staff Leasing Services Act and under the other statutes. But the court ought to look at all of the traditional indicia. It ought to say that those indicia have certain weight, as does the contract. And when actual control is not exercised, that's the biggest indicator of a lack of control that should be required to create an employer-employee master-servant relationship. And so the court ought to weight those factors, perhaps, if it wants to talk about common law employment status. But I think the court ought to give the litigants and companies and the strangely situated friend of the court, Texas Mutual, which filed an amicus in this case, suggesting that it's a friend of the court, but actually is the one that provided comp coverage to Mr. Stevenson and waived subrogation of that right. The court ought to push those parties toward the legislature's scheme. That ought to be a better way of going about this co-employment relationship.
Any other questions? Thank you, Mr. Hogan. Mr. Gunn, I believe you have 5 minutes.
Good morning, and may it please the court. I will just start with City of Bel Air. You see from the clerk's record, there's correspondence showing that it was the trial court who raised City of Bel Air with the parties, and rightly so. It is indistinguishable. The only conceivable distinction is the contract, and you've heard our answers on why the contract doesn't matter. This is the same, and what City of Bel Air teaches, not just how you apply the law to these kinds of facts, but also what's the test. The City of Bel Air is applying the traditional right of control test. That's the test. It's not new. It is old. Your 1965 decision in Anchor Casualty is one example. There are many others. And we've just given you, the parties have given you a sharp clash over what the test is. What yardstick do you apply? And you get to choose between right of control or actual control and real exercise. And that is a gigantic distinction. And we ask you, don't try to change the law from right to actual exercise. It will be a very unhappy state of the law for everyone. If you look at the depositions here, what the plaintiff was trying to develop was testimony about physical distance and the driver being here and the plaintiff being there and saying, well, you weren't actually controlling him at that instant when he's out of your sight around the truck. And the driver said, no, I can't go put my hands on him if he's on the other side of the truck. The plaintiff took that as evidence. Well, at that microsecond in time, you're not actually controlling what he does. That misunderstands the test, and that way lies misery. The supreme test will always be right of control, and the gravitational pull will always be back to right of control. Actual is
what did we mean by exercise of actual control over the details of the work in Garza?
It's certainly probative. It is relevant to right of control, Your Honor. Actual exercise can be strong evidence, no problem. Giving directions, giving a checklist, giving verbal instructions, all of that can certainly be evidentiary of right of control, but it is just evidentiary. Right of control needs to be the supreme touchstone. And I caution the court that we'll have far too many conflicting records and jury trials if we go down the road of actual control. If you remember Painter, we said we don't go task by task. We're not going to split up the day into different tasks, hour by hour, minute by minute, or else you're going to have coverage flickering on and off throughout the day. That is a very bad policy idea. Right of control is what matters, and that's why this contract is nothing. It is no evidence whatsoever on the right of control between our parties. Maybe in another case, if we had been the party to it, and Mr. Mr. Stevenson had been the party, fine. But here, these are non-litigants. The two parties to that contract are not even in this case. That contract does not deal with right of control. It doesn't mention right of control. It is not evidentiary of our right of control. We thought once the testimony was in, we took the plaintiff at his word. There's really no dispute. Who was giving you orders? Who was the captain of the ship? You didn't hear that disputed today. He was absolutely taking orders from the driver and from the route managers when he's back at the yard. Those are our people. We were in charge. Now, that doesn't mean that Taylor Smith has no role. You can have two employers for comp. Taylor Smith was, in fact, in charge of certain things. So the disciplinary episode that you heard about, that's fine. That is probative of Taylor Smith's right of control over something, administrative side. It has nothing to do with our right of control over this work. This is City of Bel Air versus Johnson all over again. Finally, on the SLSA, that's nowhere in the lower courts. It's not in the Court of Appeals. You won't find it briefed. It's not in the clerk's record. It's not in the trial court anywhere. The judgment even recites. Trial court said that the court observed and the parties agreed that both motions address the statutory workers' comp bar issue. That's what was briefed, 408.001. That's what was briefed in the motion for new trial. It's what was briefed in the Court of Appeals. The Staff Leasing Services Act is not in the case. This is up or down on right of control under the traditional comp arguments.
Any other questions? Thank you, Mr. Gunn. The case is submitted and the court will take a brief recess.